Sure how oh
So welcome everybody. I'm really pleased to see you. Anyone who's seen any webinar I've been involved before will be wondering why I'm not in my shed. I've been driven out of my shed by building works. But we're really pleased you could join us this afternoon for an hour to think about the terminally ill adults end of life bill. Gives an update, which I'm going to give briefly, a few thoughts about liability, which I'm going to give, and then we're going to hand over, and Dr. Lucy Stevenson's going to help us think through some things about anorexia and in the context of the bill, and Professor Gareth Owen is going to help us think through some issues about how exactly we classify the administration of lethal substances. I'm going to ask both Lucy and Gareth to introduce themselves when it comes to it, because that will just speed everything up. So I'm just going to crack on with some slides from me. So just very quickly, I am Alex Keane. I'm a practicing barrister here at 39 Essex Chambers, specialising in mental capacity, mental health, healthcare ethics. I'm also a professor of practice at King's, hence I don't normally deploy my title, but I'm here wearing an academic hat as well. And I'm a member of the Complex Life and Death Decisions Research Group at King's, and Gareth and Lucy are both members as well. So what I wanted to do with you was give a bit of an update. There we go, that's what we're going to be talking about, and there will be time for questions. A bit of an update, and then I want to have a little bit of a think with you about some emerging issues about how we think about liability in this context. I need to give a disclaimer at the first, to start with. It's my personal view, it's not that of any organisation with whom I work or am affiliated or work with on an ongoing basis. These slides were prepared yesterday, and the TIA bill, as I keep acronising it, is a moving target. So where are we now? Where are we now with the terminally ill adults bill? It has completed the public bill committee stage. The public bill committee was an unusual public bill committee for two reasons. First, it heard oral evidence. So 50 witnesses heard in 3 days. I was one of those who gave evidence. Gareth was one of those who gave evidence. It also accepted written evidence, and a grand total, I think, because the bill committee is now finished, no more written evidence could be sent in. 444 submissions, not 444 people or organisations, because some submitted more than one, but an awful lot of written evidence. It was also slightly unusual, the bill committee, because it was so big. There were a lot of MPs on it. A total, and this is my maths, so apologies if I've got it wrong, I think a total of 174 amendments were made. 136 were proposed by Kim Leadbeater, who is, of course, the MP who is sponsoring the bill, it being a private member's bill. So what are the substantive changes which have been made since the bill was introduced? So first is a mandatory referral to a psychiatrist in the case of concern as to capacity. When it came in, it was a mandatory referral in case of a doubt about whether or not the person was terminally ill. In case you're thinking, hang on a minute, what does this bill provide for? I'm going to come back to the core in a second. This is for the enthusiasts. This is where the changes might have been. So there was a discretionary referral to a psychiatrist in the case of concern as to capacity. It's now mandatory. There was, when the bill started out, a High Court judge had to be involved in every case. We now have a voluntary assisted dying commissioner who oversees a panel. There is a lot of discussion about precisely whether or not this is judge plus. I think it is important to note that the voluntary assisted dying commissioner will have to have been a judge, will be a current judge, but is not discharging judicial functions on the face of the bill. Nobody involved in the panel, so there's a legal member, there is a psychiatrist member, there's a social work member. The legal member is not on the face of it discharging judicial functions. But that, obviously, the panel there, the idea is to have multidisciplinary consideration at a stage in the process. Substantive changes further also include mandatory regulations about implementation. Initially, the bill just said that the Secretary of State may make regulations about implementation. It now must say, now says the Secretary of State must make regulations about implementation. I'm going to come back to that in a minute. So a replacement of CMO, so please make a note to self, stop it being so jargony, CMO, Chief Medical Officer. So initially there was going to be monitoring of the voluntary assisted dying scheme, if that's what we're to call it. It was to be monitored by the Chief Medical Officer in England and in Wales, by the CMO in Wales. It's now being monitored by the Voluntary Assisted Dying Commissioner. The other substantive change is it was supposed to be being implemented. It had a clause that said, essentially, if things have not come into effect within 2 years, all other clauses in the bill will come in, or in this act will come into effect. Kim Leadbeater, late in the day, introduced an amendment, or put forward an amendment, which was accepted, to change that to 4 years in England. The timing is going to be dictated by the Welsh ministers in Wales. So those are the substantive changes. There have been quite a few other changes, a lot around, in particular, paperwork documentation, how one does that. But in my view, those are the really substantive changes. So where are we now? Well, the core of the bill remains the same. It's about people who are terminally ill. And I think Lucy's going to pick up on some of the nuances where that hits in terms of maybe thinking about that in the anorexia context, but we're very much thinking about people who are terminally ill. It's a 6-month prognosis. There was quite a lot of debate in the Bill Committee about how one analyses whether someone has 6 months to live, but it's very firmly coded at it's 6 months. It's very firmly contemporaneous capacity to decide what to end one's own life. It's an interesting framing capacity-wise, and I think Gareth might start to touch on that also in his presentation. And the person has to be able to carry out the final act. It's not entirely clear on the face of the bill quite how much, as it were, physical movement the person has to be able to do. So for instance, would a blink be enough to trigger a machine? Or does it actually have to be someone doing something physically more? But it's very firmly meant to be a piece of legislation which is directed at the person themselves carrying out the final act. It is still not clear how voluntary assisted dying services are to be provided or by whom, because there have to be regulations, but it doesn't say how or who is going to carry it out. Although it does say it has to be, at least when it's in relation to the NHS, free at the point of use. So that's where we are now. Where are we going next? Well, what we don't have yet is an impact assessment, or indeed a human rights memorandum. The government said, and you'll recall the government is neutral, the government said we can't do, in essence, I'm paraphrasing, we can't give an impact assessment until the bill has left Public Bill Committee because we don't know precisely what the ask is. The government has committed to providing certainly an impact assessment ahead of report stage, which is when it goes back to the full House on report. But that quote there saying it will be a challenge, that's from the Lucy Anson MP. That's the government saying it will be a challenge to give an impact assessment with ample time ahead of report stage. So that's what's happening next. Next report stage is 26th of April. So I then just wanted briefly, and really to be honest, I can only be brief here, but I just wanted to flag up some issues which may be arising, interesting, and to be honest, when a lawyer like me says interesting, that's not necessarily good. But some interesting issues in relation to liabilities. I don't really want to touch on the criminal liability aspect, and I should say the clause numbers here are in the bill as it was amended in Public Bill Committee, and I'll give you a link to how you can easily access at the end, that at the end. I don't really want to be thinking about the criminal liability aspect. I want to pick up on the civil liability aspect. So this is the liability aspect as amended by Kim Leadbeater. So she moved the amendment, it was accepted, making clear the doing of any of the following does not of itself give rise to any civil liability. So providing assistance to a person to end their own life, doing any other function under the Act in accordance with the Act, or assisting to a person to seek their own life in accordance with the Act in connection with the doing of it, in connection with doing anything. Then there is an interesting subclause 1A. Subclause 1 does not apply in relation to an act dishonestly or in some way done otherwise in good faith. Well, one can sort of see that's obvious. Then 1AB, subsection 1, doesn't apply to any liability in tort arising from a breach of a duty of care owed to that person. Subsection 2 then says a court could also find there are other ways in which someone isn't liable. But what I just want to really pick up on, and I'm so sorry, I realised I didn't manage to update that clause number, it should be clause 29. Well, what is subsection 1 doing? Because actually what it's doing is it's making us focus, and I'm really glad from my perspective, all I'm interested in, I'm neutral on this, all I'm interested in is that whatever happens in terms of this bill leaving Parliament, it's good law. And so this is really focusing in on one view on, well, what duties of care are currently owed to people? Because that first sub-question, well, what does negligence look like in the context of the TIA bill? That's going to be a whole new field, because we're going to have duties of care owed to people in the delivery of assistance. That's new. But subsection 2 is also making us think through what are the existing duties of care to secure against death, secure against suicide. And I know there's an electric wire about using the word suicide in the context here. But one of the things that one has to think through is, in ordinary circumstances, if a doctor is face to face with someone who's saying, I wish to end my own life, what duties of care does that doctor owe? What duties of care would a psychiatrist owe in the context of someone saying, I wish to end my own life, and all I want is you to provide me a report saying I've got capacity to do so? And then bearing in mind that the coordinating doctor is going to be there to provide assistance, not carry out the final act. Ordinarily, if you had a doctor providing assistance to someone carrying out an act which is going to give rise to ending their life, what duties of care might they owe? So there's a real focus there. I think there's also a separate question about the panel, but just for present purposes, I want to focus in on that last bullet point, because it is really asking us and asking Parliament to be very clear-eyed about how this bill interacts with the duty on the state to secure the right to life. That's both, for instance, in the context of common law duties, and there's some case law around that, but there's also in the context of the ECHR, the Article 2 ECHR duty to secure life. And so we're going to have, and as I say, I'm extremely keen on this bill being as clear as it possibly can be on all issues, to make sure Parliament is absolutely clear-eyed about what's happening. Really, it ends up with those two questions. How does this subsection and how does the bill then fit more generally with the duty on the state as being discharged by individual doctors, at least when they are NHS, acting on behalf of the NHS? How is that to sit with the duty to prevent suicide? How do those two sit together? So I said I was going to give you some resources just very quickly before I hand over. So Lucy, get ready. Just hand over. That is my website. On there, I have got a number of resources about the bill. One of the things that I've got is a version of the bill which shows all the amendments which were made before the bill entering the Public Bill Committee and the bill leaving the Public Bill Committee, to see who made them. So I'm going to hand over. You're going to hear from me in a little bit later because I'm going to be quizmaster. But I'm now going to hand over to Lucy. I'll stop sharing so Lucy can then help us think through some things in the context of anorexia.
Thank you, Ella. So I'm hoping that's come up clearly. Yeah. Good afternoon, everybody. My name is Dr. Lucy Stevenson. I'm a consultant psychiatrist in the Maudsley Hospital Eating Disorder Department, and I've got an interest in ethics and law. And as Alex said, I'm also part of the CLAD group. And so in the next 15 minutes, I wanted to talk about how it is that anorexia nervosa, a mental disorder, has entered the debate around terminally ill adults. And as Alex said, the core of the bill attempts to specifically exclude mental disorders. It uses the language that this must be a terminal illness that is irreversible, and there's a capacity safeguard, and specifically it must not be a mental disorder. And yet it's become a hot topic of conversation. And I want to suggest there are 3 reasons for this. And firstly, there are some linguistic issues which reflect a debate within the field of eating disorders. And this is around the highly controversial concept of terminal anorexia, which also ties into arguments around the reversibility of the illness. And secondly, there's long been an issue around assessing decision-making capacity for treatment in anorexia. Thirdly, there's mounting concern that there is already a practice around providing assistance in dying for people with eating disorders. I want to make sure that I outline my approach to this topic. I'm very conscious it's an emotive issue, very complex, and I can't hope to provide here any kind of comprehensive overview, and I'm not attempting to advocate either way on the debate. But what I hope to demonstrate is my own conclusion, looking at all of this, that yes, it is very complex and that a great deal more consideration and research is required. So to dive in, I'm conscious that not everybody in the audience may be familiar with eating disorders, so I'm going to give an extremely brief clinical overview with the points that I think are most relevant to the debate, but if there are any clarifying questions, perhaps they can be picked up in the discussion time later. So this is the diagnostic criteria we use when we are diagnosing anorexia, which is only one among many of many eating disorders. Just to note that here we have a mental disorder where a key feature is actually a physical characteristic. And here we have perhaps the first point of strain in the bill. And conditions like anorexia, also along with dementia, really put stress on our conceptual distinction between mental and physical disorder. Because of course, in anorexia, you have both mental and physical causes and mental and physical effects. And to make a diagnosis of anorexia, and this is adult diagnostic criteria, a person must have a BMI of below 18.5, a particular pattern of behaviours which aims to maintain a low body weight, and particular patterns of cognition, which are around preoccupation with body weight and shape. How do these complex disorders come about? Well, we understand anorexia and other eating disorders to be a perfect storm of both biological and psychological predisposing, precipitating, and perpetuating factors. And just as the causes of these illnesses are biological and psychological, so are the impacts. And you have, in anorexia, you have a multi-system physical impact that can be lethal. And anorexia probably has one of the highest mortality rates of any psychiatric disorder. But of course, anorexia nervosa is not always lethal. They're not inevitably lethal. And the field has grappled and is still grappling with how to understand, predict, and ultimately personalize treatments for those at varying degrees of risk. And one model which attempts to understand the trajectory of eating disorders takes a staging approach, which plots the course of an eating disorder from an early prodromal phase to an established illness to a more long-standing illness, where changes are more difficult to reverse. And it's estimated that around 50 to 80% of those diagnosed will make a full or partial recovery. And it's around 20% that have these long-lasting difficulties that might occupy this sort of red square at the end. Anorexia lasts for a long time. The median duration of illness is around 10 years, and the standardized mortality ratio is 5.9. And this is higher for those admitted to eating disorder units. It's about 15.9 for women and 22.4 for men. And there are various factors which impact prognosis. And these are the age of onset, the level of malnourishment, the time to treatment, and comorbidities. And in terms of a treatment approach, it's pretty uncontroversial for those on the left-hand side of the diagram that have a prodromal or an early illness. And the profession is united that here the crucial thing is that intensive treatment aimed at weight restoration is provided as early as possible. And there's good evidence that providing treatment early really is powerful in altering the trajectory of these illnesses. And watchful waiting is really to be avoided. However, for those who have more established illnesses, so in the sort of the orange and red end of the scale, there's a lot of variation and controversy about defining these groups and how we treat them. And for this group, this sort of 20% group on the more severe end of the spectrum, this may involve considering the focus of care, whether a focus on weight restoration is required or whether we need to take an approach which focuses more on harm reduction and enhancing all possible quality of life for that person. But as I said, it's extremely challenging within the field to think about how we define this group, how we talk about them, and how we treat them. And of course, this is really important to think about how we govern, how we might practice around research and how we develop new treatments. And into this, and these terms here are taken from a review, a systematic review by Broomfield and colleagues, looking at the varying terminology around these longer term presentations and thinking through the significance of the various labels that we might use for people affected and their carers. And into this controversy in the field dropped this particular paper a few years ago, and of course the language of terminality in the bill. And there was this paper published by Jennifer Gaudiani, who's a respected clinician in the field. She's a physician working in Denver, Colorado. And in this paper, she coined this new term, terminal anorexia, and presented 3 case studies, giving an example of people who she said fitted this definition of terminal anorexia. So this is actually been withdrawn, the term, after significant debate in the field, but nonetheless, it's something that has really stayed in the mind and has become quite widely known. And this is how Gaudiani defined terminal anorexia. She said that somebody needed to have a diagnosis of anorexia, they needed to be aged 30 or older, they needed to have had a good experience of care, and this care had been unsuccessful in achieving recovery. And there needed to be, this person needed to have the capacity to understand that further treatment is futile, they choose to stop prolonging their lives, and they accept that death will be the natural outcome. And this prompted a lot of controversy in the field, and there are multiple papers written about this. The paper I want to refer to here is actually being written. It's not available yet, and this is a systematic review of the ethical arguments for and against the concept of terminal anorexia. It's currently being put together by somebody called Chloe Connor in the States, so we're watching this space. In the meantime, what I've done is borrowed from another paper, another systematic review of ethical arguments for and against assisted dying for people with psychiatric diagnoses by Nicolini and colleagues. And I think some of the categories that they use are helpful in just summarizing the debate around this term, terminal anorexia. So people who are in favor of using this term, terminal anorexia, argued that this kind of language, this kind of concept ensures parity of care for people suffering with a severe illness, such as an eating disorder, compared to people who have access to palliative care and assistance in dying who are suffering from physical illnesses. And this is about equality of access to good care. It's also about acknowledging the reality of the suffering that people are experiencing and being honest that this can be just as extreme for people living with severe eating disorders as those with physical disorders. People also argued that this is about allowing the person the dignity of self-determination and authenticity. This is about equal respect for a person who has a long-standing eating disorder and wishes to end their own life, who wishes to refuse treatment. It's also about being consistent with the overall goals of medicine and psychiatry, which are about being therapeutic. And people argued that openness to the reality of the severity of terminal anorexia is therapeutic in itself, whereas prolonged compulsory treatment is invasive and not therapeutic. And taking this stance around terminal anorexia removes pressure from carers as custodians and can support quality time and alliance as a person faces the end of their life. And then there is this slightly complex argument around irremediability. And this really slides into concerns around the wording of the bill about the reversibility of illness. And the bill tries to exclude non-physical health conditions, non-terminal physical health conditions by saying these illnesses cannot have to be irreversible. And the arguments around irremediability in terminal anorexia go something like this. People say that malnutrition and dehydration are terminal illnesses. They naturally result in death. And if somebody is capacitisly refusing food and drink, we cannot give it to them. And therefore, the condition is irreversible and terminal. So the physical sequelae of starvation, of anorexia, is itself terminal, and if it can't be treated, therefore it is a terminal illness. So unsurprisingly, this sparked a lot of controversy, and people raising concerns about this issue said, well, no, death is not the result of lack of effective treatment, but refusal of treatment. And recovery does remain possible for over 60% of people, even after 20 or more years of illness. And medical complications are reversible, that there is treatment. On the parity argument, people argued that access to palliative care does not necessarily require a terminal diagnosis, and that this terminal language is directly imported from cancer staging, which is simply not appropriate for psychiatric illnesses. And then people worried about the consequences for mental health care, the consequences of using this kind of language of terminal anorexia, how that might really take away from attempts to instill a sense of hope for the individuals and for their carers. And then we come to this issue of mental capacity in anorexia, and the bill attempts to introduce a safeguard saying that this person must have capacity to make this very significant decision. And with anorexia, there are probably two questions here around capacity that get quite tangled. The first is around refusing treatment, which in anorexia is nutrition. And the second is around making a request for assisted dying. And the latter is complicated in any situation. And I think, thankfully, Gareth is going to, I think, talk a little bit more about that. In anorexia, there's the particular issue around treatment refusal. And I think this is for really two reasons. And it's both because of the nature of the disorder, the nature of anorexia, and the nature of the capacity assessment. So in anorexia nervosa in particular, there is good reason to question a presumption of capacity. And that is because of what we know about the impact of starvation in the brain. Basic science informs us that there is a significant impact on how the brain functions, and also the basic physical state of the brain. It literally shrinks. And we tell our patients the brain is the most hungry organ in the body. It needs at least 500 calories per day to function. And animal models suggest that in stress-susceptible individuals, in the presence of stress, it might become, and starvation, it might become extremely difficult for them to choose a potentially rewarding option. Psychological research also informs us about how starvation changes the way we think. It might cause memory problems, cognitive rigidity, mood changes, and there's this sense of the anorexic cognitions, the anorexic identity dominating and taking over all other aspects of a person's thinking. So why is it so difficult? Well, assessments with anorexia nervosa are complex because in spite of the impact of starvation on the brain, general cognition often remains very well preserved, and difficulties around decision-making are highly decision-specific. It's very hard to untangle the authentic person from beneath the disorder. And the person might have underlying beliefs about being unworthy of help, not sick enough, and betraying the eating disorder. So that's why the nature of the disorder, something about why the nature of this disorder makes capacity assessment difficult. There's also the nature of the assessment. And it's a common criticism of functional capacity criteria, that only the impact of cognitive difficulties rather than emotional difficulties is accounted for. And we know that this is probably where a lot of the difficulty lies in anorexia. And there was a researcher called Jacinta Tan that did some work exploring capacity with people who have severe anorexia. And she came up with this idea that in anorexia, you have pathological values, which impact how people use and weigh information. And she identified value shifts as a key marker of thinking change in the disorder. But again, acknowledge this difficulty, that it's very difficult to determine whether this valuation of thinness and weight loss came from the person themselves or their, sorry, that's confusing. It's very difficult to understand whether the decisions about treatment are really coming from the person themselves or their illness. And also in anorexia, and it's perhaps less talked about, there's the impact on the assessor during the assessment. And here we use language really taken from psychoanalytic thinking to think about what is it like as a clinical assessor to be in a situation where you are tasked with assessing capacity. And common experiences for people in this situation are they might find they have instincts to heroically rescue this person in huge amounts of distress and employ coercive measures. Or they might find that they feel pressurized into making decisions that alleviate their own distress or take control of a very difficult situation, or even pick up on a person's wish to avoid care and you know, to be left alone by services. Also, there's the issue about what service users prioritize, and there's some research which suggests that the important thing for the service users is not the determination of whether they have capacity or not, but the type of relational environment that they're offered through the process of assessment and even coercive treatment. I think it's important to note that, actually, and I'll move on to this, that this sort of third issue that really has raised concern around the debate in assisted dying is that there is already an international practice around offering assistance in dying to people with eating disorders. And I have a huge amount of thanks here for Chelsea Roth from Eat, Breathe, Thrive, and she has done a very helpful review of all the available international cases where assistance in dying and eating disorders has been offered. And she found that in these cases, the vast majority of people were said to have capacity to make a decision to go forward with assisted dying, and that criteria of terminality were used, and that this was part of the rationale people used in providing assisted dying. But there were serious concerns raised around the lack of reporting standards around assisted dying and eating disordered, huge variation in rationales, and lack of evidence base for these very weighty judgments. Okay, I'm going to stop there, but not before I've given huge thanks to all the people who helped me put this presentation together, from the Maudsley Eating Disorder Department, and also Chelsea Roth from Eat, Breathe, Thrive, and Johanna Keeler from King's. Thank you. Alex, I'll hand over to you. Alex, I think you're on mute.
I was just going to thank you for doing such a brilliant job of self-chairing timing-wise. So good. In fact, I could just leave myself on mute. Gareth, over to you, please.
Okay, thanks, Alex. Thanks, Lucy. I'm taking you can see me and hear me, and you can see the slides. So great pleasure to be back in this collaboration between CLAD and 39 Essex. I'm an academic psychiatrist at King's, and part of this CLAD group that we've got, complex life and death decisions. So I'm going to be addressing this question: is assisted dying a treatment? So you need to picture the scene. It's the last day of the Public Bill Committee in the House of Commons for the TIA bill, and it's around 12 midnight. Everybody's getting tired. This is the end of the process. But a new clause is introduced, clause 34, and it says assisted dying under this act shall not be considered to be a medical treatment. Now, the minister representing the government's position has to respond to this and says, as drafted, the bill is silent on the question of whether the provision of assistance under this bill can be considered a treatment. So the question arises, is assisted dying, or AD in short, a treatment? Now, the approach I'm going to take to this question is in part factual. So it's just going to be trying to ask, as a matter of fact, is assisted dying a treatment? And I'm going to take an international descriptive approach here, and with special thanks to Maria Kanayatz, who's a medical law MA student with us at King's. And then I'm going to take a different approach, which is more conceptual evaluative, which is looking at the question from the point of view of clinical ethics, but also looking at the question in relation to existing norms, legal norms, the norm of informed consent for treatment, or the doctrine of informed consent, but also the legal norms that are embodied in our NHS Act, which define the duties of the Secretary of State for Health. And then we'll look at this, the implications of this for the TIA bill. Now, just to start, let's just remind ourselves that assisted dying laws, all of them across the world, relate to a decision for a patient made with information, mental capacity, and voluntariness. Okay, so that's a shared sort of conceptual feature of all of the assisted dying laws. But of course, the question is, what is considered relevant information for the patient? And how is mental capacity made functional? That is to say, mental capacity for what? So what I'm going to do now is try to clarify the nature of the assisted dying decision, i.e. what kind of decision we're really talking about, by attending to these elements of the laws, because a well-written law really should specify these two things. So it's like a kind of laser, as it were, that's going to be applied now to all of the statutes that exist internationally. Now, what we've done when we look at the language in relating to this is that it's possible to form a typology or a grouping of assisted dying statutes. So there's one group of statutes where it's pretty clear that the decision is being framed and described in the language of the law as a healthcare or a treatment decision. So the best example of that is Canada, but there are other jurisdictions in the US and also the Netherlands, really, which take that characterization of the decision. There's another grouping in which the decision itself is described ambiguously, really, or in a rather circular way, as a decision in relation to the law itself, the assisted dying law. Now, there are a bunch of examples of that. They're including Australian jurisdictions, Spain, but closest to home, actually, the Scottish bill. So the bill that's in the Scottish Parliament. There's another grouping where it's really not possible to say what it is for. So it's what's really happening here is that it's a decision that's related to a general capacity idea, which is not functionalized, and there are a bunch of jurisdictions which are classifiable on that basis. And then you come to us here in England and Wales with the TIA bill, where very clearly the decision is stated as a decision to end one's own life. Now, whether you call that a suicide decision or not is going to be an electric type issue that Alex referred to, but that's the decision. It's the decision to end one's own life. So it's in our bill in the Westminster Parliament currently. It's in the Isle of Man, which is now going to become an act. And something like it is also in Germany and in Switzerland. So in answer to the question, as a matter of fact, is assisted dying a treatment? Depends, in fact, on what jurisdiction. So it will vary according to the jurisdiction. Now, a group that we're interested in is this ambiguous group here, which includes the Australian jurisdictions and also Scotland. So if the law itself, the black letter law is ambiguous, what about the guidance? So what do government, when it comes to government guidance, how do they add further clarification? So when the statute's ambiguous, what does the government guidance say? Now, an example is the state of Victoria in Australia. So this was the first Australian state to introduce its voluntary assisted dying, or VAD Act. And these are the government guidance for health practitioners. And I'll just walk through them a little bit, which is there's a table in these guidance, table 4, which talks about assessing decision-making capacity in relation to VAD. So that's the object, as it were, of the capacity assessment. The patient's got some tasks according to this table, and the clinician's got some tasks. Now, when you look at those tasks, it looks as if it's probably being considered to be a treatment amongst other treatment options. So the patient must remember information provided about treatment options, including voluntary assisted dying. The clinician has to ask questions like, have you decided which treatment option to follow? And statements like, that medical practitioners should follow their normal practice for discussing treatment options is included. Now, interestingly, this government guidance includes the statement, which I think is a correct statement. There are no validated tools specific to assessing decision-making capacity in relation to voluntary assisted dying. Okay, so there's an acknowledgement here that we're not talking about validated tools, we're talking about guidance, and that the tools, which are referred to in table 5, are tools and resources for assessing capacity that were developed in the determination of medical decisions. And the references here are clearly treatment decisions. This is Paul Applebaum in the States, who developed guidance for capacity for treatment decisions, and the National Institute of Clinical Excellence in the UK, which have got guidance which are around health and social care decisions. Now, similar patterns exist in the guidance from other Australian jurisdictions and also in Spain. So it's a similar across all of this group where it's ambiguous. So there is a tendency, when it's ambiguous, to treat assisted dying as if it's a treatment option. So this now brings us to the second part of the analysis, where we were engaging with norms or normative issues. And the first is a clinical ethics one, which is the question, what is treatment? Now, I think a pretty standard definition of treatment would be that it's an intervention aiming to improve a patient's health. But assisted dying can't aim to improve a patient's health because health is unintelligible outside of life. I mean, we understand what improvement of health means in the context of a life. Outside of a life, it's not intelligible. So that can't be a treatment. So assisted dying can't be a treatment according to this meaning. But what about a meaning that's more focused, a more holistic sense that's focusing on suffering? And of course, we acknowledge that in healthcare, what we mean by treatment can have this holistic sense, and that's particularly true in palliative care. This could be an understanding of treatment that it's an intervention aiming to relieve suffering of a patient. Now, sometimes the term unnecessary suffering is added. I actually think that's an important qualifier. And an interesting, if you want further reading, discussion of this is this link here, which relates to the Lancet Commission on Palliative Care, where one of the lead authors discusses this question of unnecessary suffering in the context of end of life. But assisted dying can't aim to relieve suffering. I mean, relieve means reduce, it doesn't mean end. Because assisted dying ends the possibility of suffering itself. I mean, that's what's happening. And so it does that and may also end kinds of suffering that have no inherent relation to health. Now, that's just important to bear in mind, because suffering is not in itself a healthcare matter, which is the purpose of this unnecessary qualifier. So some forms of suffering we consider as very important features of our humanity. They're not features that are inherently related to health. So assisted dying can't be a treatment according to this meaning either. Now let's turn now to some of the existing legal norms. I want to just raise some questions here in relation to existing legal norms, and what happens if law considers assisted dying a treatment. Well, the first thing to think about is how it interfaces with the doctrine of informed consent. Now that's now come to the UK through, at least officially, through this famous McCulloch judgment of the UK Supreme Court. Now, given that we've got this doctrine of informed consent now, there's the question about whether it will require a doctor to bring up assisted dying, if it's a treatment option, as one, and conversely, would a failure to do so render the doctor liable in negligence. So as soon as you frame assisted dying as a treatment, it's going to enter into this legal logic. You can ask further questions. If the patient were to refuse assisted dying, would that be a refusal of treatment? What would be the consequences of that? And if it's a treatment, why would assisted dying be limited to adults with capacity? That would be a further question to ask. Of course, we consider treatment within best interests. Now, this is a very interesting legal discussion of these questions, which has in fact been produced by the Law Society of Scotland. So it's a Scottish legal document, and these are the pages which I would particularly draw your attention to. Now, the other norm, which is very relevant to us, is the norm relating to the duties of the Secretary of State within our National Health Service. Now, in section 1.1 of the NHS Act 2006, we have that the Secretary of State must continue the promotion in England of a comprehensive health service designed to secure improvement in the physical and mental health of the people of England. Now, many commentators will take that really as the foundational principle or statement of a socialized healthcare system, such as the one we have in England with our NHS Act. Now, if assisted dying as a treatment relating to the improvement of health, then that would imply that the Secretary of State for Health must continue the promotion of assisted dying for the people of England, or at least one can ask that question. It seems to flow out of that legal duty. So to summarize, what have we been saying? Well, the TIA bill, so the bill in the Westminster Parliament, proposes a decision to end one's own life in terminal illness. That's the way it's framed. Now, that's not a treatment decision, at least on its face, it's not, and it's also not an ambiguous decision. I think it's clear what that means. It requires a distinctive capacity test, the capacity to end one's own life, and we're learning quite rightly from the Australian guidance, but also from others, is that we don't have a validated test for that capacity. So we're in new territory with this capacity evaluation. In assisted dying statutes, where there's this ambiguity about what kind of decision it is, there's been this clear tendency towards a treatment interpretation in the government guidance. So if we are ambiguous about it, even in our own minds, it looks as if there may well be a tendency for us to consider it to be give a treatment interpretation to it. So the next question is that the next point is that that's important because because assisted dying isn't intelligible as a treatment on standard medical ethics concepts of treatment. So if we wanted to think about it as a treatment, we'd have to be doing some very radical work, I think, to be considering assisted dying as a treatment. And framing it as a treatment has major complexities for the legal doctrine of informed consent, and for the legal duty of the Secretary of State of Health to promote and provide health. So what does that imply for the TIA bill? Well, the current position of government, as we started with, is neutrality. And specifically, it is said that the TIA bill is silent on whether assisted dying is a treatment. So what I think I just want to leave you with is the thought that this midnight hour question needs further debate in Parliament. Thanks very much.
Brilliant. Thanks very much, Gareth. So we've now got 9 minutes for questions. I am going to play Question Master. Lucy, there are a couple of really interesting questions which are looking, as it were, the opposite end of how one might think about eating disorders. So as opposed to anorexia, one person's asked about Prader-Willi and another person's asked about conditions which involve binge eating. I'm wondering whether there are any thoughts you might want to give there.
Yeah. So I suppose I think what I'd want to check in with, I think
Actually, Lucy, sorry, just before getting there, I've just realised I should have said we're not going to record the section relating to questions and answers. So for anyone who's watching just the recording of this video, you're left with an incredibly tantalising cliffhanger. Thank you so much for watching the video. We'll now stop recording and then back to Lucy. So